Breezy!
Artists shall conduct themselves with due regard to public conventions and morals, and shall not commit any act or become involved in any situation or occurrence which will reflect adversely upon the reputation of the studio. That language doesn't come from a congressional resolution. It isn't a loyalty oath. It's a standard clause in a modern talent agreement, the kind signed every week in Hollywood. Now consider what the studio heads agreed to in November 1947, gathered at the Waldorf Astoria in New York, that they would not knowingly employ communists or other subversives. In the 1950s, ending a career required a congressional committee, public hearings, and an industry-wide pledge. Today, one clause in a private contract achieves the same result. The venue changed. The mechanism didn't. To understand how that clause became so powerful, you have to go back to where it started. In 1921, comedian Roscoe "Fatty" Arbuckle was accused of manslaughter following a party in San Francisco. He was tried 3 times and acquitted on all counts. The evidence didn't matter to the studios. Universal responded by inserting language into actor contracts prohibiting conduct tending to degrade the actor in society or bring him into public hatred, contempt, scorn, or ridicule. The morality clause had arrived, not as a legal standard, but as a reputational insurance policy. By 1934, the Hays Code formalized a parallel system of control. The Motion Picture Production Code didn't just censor what appeared on screen. It signaled to studios that talent's off-screen behavior was a legitimate business concern, one with commercial consequences. The industry had built its own regulatory framework before the government thought to impose one. Then came 1947. The House Un-American Activities Committee subpoenaed 42 Hollywood figures, and 19 were deemed uncooperative. 10 of them, screenwriters and directors including Dalton Trumbo and Ring Lardner Jr., refused to answer the committee's central question, whether they were or had ever been members of the Communist Party. They cited the First Amendment. Congress cited them for contempt. On November 25, 1947, 50 studio executives gathered at the Waldorf Astoria and issued a coordinated statement. They would suspend the Hollywood Ten without pay and would not knowingly employ communists or other subversives. No formal list existed. None was needed. The studios had existing morality clauses in their contracts. Political disloyalty was reframed as moral turpitude, and termination followed without severance, without compensation, without recourse. The economic mechanics were precise. Suspension without pay meant no income. No severance meant no cushion. The standard remedy for a morality clause violation left both parties without financial obligation, which in practice meant the studio lost nothing and the talent lost everything. What made the system particularly effective was how broadly it defined liability. Of the 204 Hollywood professionals who signed an amicus brief defending the Hollywood Ten, 84 were themselves blacklisted. They hadn't testified. They hadn't been subpoenaed. They had signed a legal document in support of colleagues. That was sufficient. The standard of proof wasn't legal. It was reputational. Proximity to a scandal was treated as participation in it. Dalton Trumbo became the defining case. Jailed for contempt, blacklisted for over a decade, he continued writing under pseudonyms, including the script for Roman Holiday, which won an Academy Award credited to Affront. His public credit on Exodus and Spartacus in 1960 marked the informal end of the blacklist era. The congressional hearings wound down. The contractual infrastructure they had relied on did not. The 1948 Paramount antitrust decision forced studios to divest their theater chains, dismantling vertical integration. Studios lost control of distribution and exhibition. What they retained were the contractual tools. And over the following decades, those tools quietly expanded. Through the freelance era of the 1960s and 1970s, morality clauses persisted in modified form. Invocations were handled privately, typically in rooms with lawyers on both sides, without public disclosure. The clauses existed. They were simply used with discretion. That discretion began to erode as the stakes grew larger and the media environment became less forgiving. In 2011, Warner Brothers and Columbia Broadcasting System terminated Charlie Sheen from 2.5 Men mid-production. The termination letter cited conduct, language, and behavior deemed harmful to the cast, crew, and production. Sheen's contract contained moral turpitude provisions and workplace conduct standards. He subsequently claimed over $100 million in damages. The dispute was resolved through negotiation, not a public verdict, but the mechanism was the clause, not a court, not a committee. In 2018, American Broadcasting Company canceled Roseanne within hours of a viral tweet by its star. The network's standard talent agreements included language allowing termination for conduct materially injurious to the reputation of the network and its affiliates. No hearing was convened. No evidence was weighed by an independent body. A single clause and a phone call ended a production that had drawn over 18 million viewers. The Kevin Spacey case moved the architecture further. Following misconduct allegations in 2017, MRC removed Spacey from House of Cards mid-production. The dispute proceeded to judicial arbitration and mediation services, or JAMS arbitration. Private, confidential, resolved without a public trial. The arbitration resulted in a reported $30.9 million award against Spacey for breach of conduct policies embedded in his production agreement. The proceeding was never entered into a public court record. That last detail matters structurally. By the mid-2000s, legal analyses of major studio talent contracts found that 85% of reviewed dispute resolution provisions mandated binding arbitration, with the overwhelming majority specifying JAMS exclusively. Disputes moved from courtrooms to private chambers, eliminating public precedent and press scrutiny simultaneously. The language driving these terminations carried no statutory definition. Terms like moral turpitude, public disrepute, and conduct reflecting adversely upon the studio were enforced at the studio's sole discretion. There was no external standard to appeal to. The clause meant whatever the studio decided it meant, resolved in a forum the studio had contractually selected in advance. The Sheen, Barr, and Spacey cases each involved conduct directly attributed to the individual. What the post-#MeToo movement era introduced was something structurally different. The extension of morality clause logic to association, to proximity rather than action. When Harvey Weinstein's conduct became public in October 2017, studios didn't just terminate Weinstein, they revised their contracts. The standard of triggering conduct shifted from criminal conviction to any act causing public disrepute, scandal, or embarrassment, including allegations and social media backlash. The revision was industry-wide. It moved the threshold from what a person had done to what a person could be perceived to have done or been near. The practical consequence was significant. Talent named in published investigations, not charged, not convicted, sometimes not even credibly accused, faced documented professional consequences because their association with accused individuals created reputational risk for the studio's brand. The clause didn't require a legal finding, it required a reputational one. That logic extended further as high-profile criminal cases generated public document releases. Following the federal charges against Jeffrey Epstein in 2019 and the subsequent unsealing of court records, including flight logs, deposition materials, and correspondence entered into public record, individuals named in those documents faced professional consequences that had no basis in criminal liability. Talent agencies lost clients, executives resigned, institutions reviewed existing contracts. In 2025, Casey Wasserman, chairman of the Los Angeles 2028 Olympics Organizing Committee and head of the Wasserman Talent Agency, announced the sale of his agency after 2003 emails with Ghislaine Maxwell surfaced in Department of Justice files. No criminal charges were filed against Wasserman. Clients, including Grammy winner Chappelle Roan, departed. The reputational association was sufficient to trigger a forced restructuring of a major talent representation business. This is where the parallel to the 1950s becomes structural rather than rhetorical. In that era, appearing on an American Legion list or signing an amicus brief was sufficient to trigger studio action. The standard of proof was reputational, not legal. Today, appearing in a flight log or a deposition exhibit entered into public record can activate association language in a private contract. The standard of proof remains reputational, not legal. The venue moved from congressional hearing rooms to arbitration chambers. The lists moved from American Legion pamphlets to Department of Justice document releases. The mechanism is the same. Some arbitration decisions and California court rulings have found overly vague morality clauses unenforceable. Talent with sufficient leverage now negotiate reverse morality clauses, allowing them to exit if the studio's own conduct damages their reputation. But those protections require leverage to obtain. Most talent, particularly mid-tier performers without guild protections or negotiating power, sign broad clauses without modification. The blacklist as an institution ended in the early 1960s. The contractual language it relied on was never retired. It was refined, expanded, and moved into private arbitration, where it operates without public record or judicial scrutiny. What changed was the venue. Congressional hearing rooms became arbitration chambers. American Legion pamphlets became DOJ document releases. The committee hearings ended. The paperwork didn't. If this series interests you, subscribe and watch what comes next.